Good afternoon, everyone. Thank you for joining us for the this month's webinar, where we're going to be looking at philosophical beliefs in the modern workplace. I'm going to slightly slowly go through our first couple of introductory slides, just give those that might still be trying to get onto Teams, join, sign up, etc. A moment to join us. But hopefully most people, those of you who are prompt and ready to go, are all here and with us. So just if we, so as I say, we're talking about philosophical beliefs today, and if we go to the next slide, Isabella, the next slide we have here is just a bit of introduction about the firm. It is, frankly, just a bit of general information that we're obliged by marketing to include. It's there. Most of you probably are aware of who we are, given you've signed up to the webinar. So moving on from that one, a bit of introduction about myself and Isabella here. We both are sort of within the employment team. So my name's Sam, and I've said Isabella's name about 4 times over now. And she's with us and will be joining us as part of the webinar. So let's go over a bit of what we're covering. So philosophical beliefs in a modern workplace, and why is that really important? I mean, we've got an ever-growing and diverse workplaces, and I'm sure that's something most employers have seen over the years, and which means you've got people from all different backgrounds, cultures, holding different beliefs, be it socioeconomic, backgrounds or cultural ones and things like that. And it means we have a bit of a melting pot of, through that diversity, which is fantastic for all the right reasons, but doesn't come without potential issues and problems, particularly where there's so much going on in the world and globally, which impacts on people's beliefs and things. And ultimately, that can lead to potential for conflict, management issues, and all sorts. And from a legal perspective, and looking at the employment law, is something that there's been numerous cases, in particularly I'd say in the last 10 years, on that topic, and the sheer volume of cases on that topic just shows how difficult it can be to manage and assess those positions and address, and the frequency that it does come up, which is why we've selected it as something we thought would be worthwhile going through and discussing today. So throughout the course of the webinar today, we're going to be looking at what do we mean when we're talking about philosophical belief and a protected belief? So what is protected, and some examples which come from recent cases as to what may or may not be a belief. If there is a protected belief, well, what does that mean? What protections does that offer for a person holding that belief? What do we mean by a manifestation of the belief? Because that plays an important part in this. And really, what the practical aspect. So how should beliefs be handled in the workplace? What happens when those beliefs come into conflict? Naturally, there's plenty of examples where people are going to disagree on things. And if one of those is a protected belief, well, what then? And what protections are there, and what should people be doing, and what steps can we take to mitigate the potential repercussions that come from that? So really the practical management of those things. So getting into all of that, and to warm us all up to it, because it is quite a heavy topic and there's a lot of content we've got to go through, I wanted just to cover really well what's the legal test? How do we categorize something that's being protected as a philosophical belief? And this really falls into part of, so as a lot of you may know, under the Equality Act, we have a set of protected characteristics. Okay, and that obviously covers all the the ones most people know off the top of their head. So things like disability, race, gender, sexual orientation, and things. And one of them, and again, it's a very common one, is someone's religion and belief. And whilst religion, mainstream religions are obviously a lot easier to identify and be aware of, the term belief is where this almost ambiguity and can come into it. So it's looking at, well, what is a protected belief? And the test that you can see at the moment through those bullet points on the screen there is what's obviously been developed through case law and things, and is how we would assess a belief to be protected under the Equality Act. And for a belief to be protected, it needs to be a genuinely held belief. One that is a belief rather than just someone's opinion or viewpoint based on a present state of information available to them. It must concern a weighty and substantial aspect of human life and behaviour. And it must attain a certain level of cogency, seriousness and cohesion and importance. And on top of all that, it needs to be worthy of respect in a democratic society, and be not incompatible with human dignity or conflict with someone's fundamental rights. I'll be the first to admit and recognise that's a very long way, drawn out test, which doesn't necessarily provide a huge amount of clarity to people, particularly, when you're sat there looking at it, perhaps in a practical position, trying to assess, well, is the situation you're dealing with, will this be a protected belief or not? But that's precisely the reason it's been sort of dealt with so much by the tribunals and courts, because it is not a straightforward position. It's simple as that. If something does become a protected belief, and we'll talk a bit more on this later, then it's a protected characteristic under the Equality Act. They have those usual protections against discrimination and such like, and that's why it's very important to take this seriously and be aware of them, because you don't want to be straying into obviously the issues of discriminating against perhaps an employee. So we then have a couple of sort of scenarios put together, and these are just some of the perhaps more slightly straightforward examples, but they derive from actual cases, and we thought it's just, again, helps people sort of get their heads around some of this and into the flow of it. So this first one, we have someone by the name of Abdul, who is in a marketing role, and Abdul follows ethical veganism. And as part of that, he avoids all animal products, and we're not just talking dietary. He will not wear leather and etc. and use perhaps products that have been subject to animal testing or contain animal products within them. Actively supports animal rights charities. Refuses to work on campaigns, i.e. work with clients etc. whose products might involve animal testing. And he says he basically has a deep belief about animal welfare and living without causing harm. So take a moment. We don't have a sort of voting system or poll set up, but take a moment to have a think. Would you say that belief would be a protected philosophical belief under the Equality Act? Now, the answer to that is yes. It would be. Certainly, that's what the tribunal found in this case, that ethical veganism could amount to a protected philosophical belief. A tribunal found that it had the high level of cogency, cohesion and importance. There was no conflict between that and human dignity, and it didn't offend society in any way or conflict with anyone else's rights. So it was found that what was an example where it could be. Now, taking by contrast then I'm sort of giving away the answers, but the next one, we then have an individual by the name of Jess. Now, in this example, and again, this all derives from an actual case, Jess believes that everyone should show respect for those that have died at war by wearing a poppy from the 2nd of November, being All Souls Day, through to Remembrance Sunday. She feels very strongly that this is the right way to honour those who have died at war. She gets frustrated and expresses that frustration where her colleagues may not be wearing a poppy, and she raises concern with management about people not doing so. So, again, the same question is, does this belief qualify as protected philosophical belief under the Equality Act? The tribunal here, obviously, as I gave away by saying by contrast, found that it did not. Okay. They certainly didn't criticise her for holding the belief, and they have no issue with the belief itself. Indeed, I believe the term used by the tribunal was that it was admirable to hold such a belief. However, it lacked the required characteristic of cogency, cohesion, and importance, and was not be described as relating to a weighty and substantial aspect of human life and behaviour. Okay, so this is one where it really falls into more of the category of an opinion, not a protected belief, and therefore wasn't protected under the Equality Act. So there's just some active some examples. So I've then got a bit more as to, well, what could count as a belief? And as I suggested at the start, those religious beliefs, particularly mainstream religions and so on, are relatively easy to recognise. So I won't really go through and explain those to people because I appreciate everyone will have that awareness and they are going to be protected. But philosophical beliefs can cover such a wide spectrum of things, and perhaps some that might strike people as obvious, and some that may not. And you'll see there is a list of some, included on the slide there. I don't intend to go through each one of these one by one and break them down or explain them, but I certainly will with a few of them. Perhaps some of those which might be viewed as a bit more controversial or shocking, or just from my view, but I think a bit more interesting. So looking at the belief that lying is wrong, I think this is a relatively interesting one because it's almost quite a vague, on the face of it, quite a vague sort of sounding belief. But ultimately, so and all of these examples here again come out of actual cases which have generally been heard, across the last 10 to 15 years or so. And in this instance, the case was to do with a salesperson who was ultimately, dismissed for performance reasons, i.e. for not meeting his sales targets. However, he then gave evidence that he had been told to lie to customers to achieve sales. And he argued that there was effectively indirect discrimination on the basis that he held the belief it was wrong to lie under any circumstances. And the tribunal certainly found that that belief, had weighty and substantial aspects of human behaviour, a level of cogency, seriousness and cohesion, and was important, worthy of respect in a democratic society. So it ticked those boxes. Now, his belief did originate effectively from his Christianity. But this wasn't discrimination against him, for being a Christian. It wasn't to do with his religion. It was to do with that belief he held on lying. Ultimately, that belief is likely to be central to many, if not all, religions anyway. We then have gender critical beliefs right under that one, and this one is always quite relevant and has been probably one of the more publicised topics in recent years, and one of the key cases which many of you may have heard. And I've not been necessarily naming all the cases because I think it would just be death by case if we did. But this one I will mention because it's probably one people are aware of, is Higgs v Farmers School. And I'm not going to go through the entirety of that case here and now, albeit we're going to end up referring to it again later. But from the point of gender critical belief, what we mean here, and in this case, Higgs had a belief in gender fluidity and a lack of belief that someone could change their biological sex or gender. And the tribunal did find that her lack of belief in that gender fluidity was still worthy of respect in a democratic society and capable of protection. And that's obviously one that's going to, if you think about having, if you have across a workforce, that's something I would say is a topic that people are more likely to have sort of conflicting beliefs about, which is why some people might find it perhaps more surprising that it might end up being a protected one, but it certainly was found to be so. And that wasn't really the crux of this case. The case then goes on to deal with how she manifests that belief, which is what we're also going to come into later in the in the webinar. And the last one, again, I'm not going to go through the case in full detail, but it is a bit of a shock factor almost, is that we have belief that a medium can communicate with the dead. And I think when you're talking about things such as, having worthy of respect and things like that, people may be more surprised on that one. However, it very much linked into things that having belief about life after death, and linking to religion and things, and therefore there was belief of use of mediums can be worthy of respect still in democratic society and still have sufficient cogency, seriousness, and cohesion. So there's some examples and clear examples of things that have been found to be a philosophical belief. It's also worth obviously mentioning that the opposite side of it, those that have not. And again, I won't go through all of these one by one. I'll probably just take that. In fact, well, I won't mention. I think I'm going to end up mentioning most of them. But the top one about 9/11 and the 7/7 events. This was found. So the belief held here was effectively that these were false flag operations. We're talking effectively individual who had the sort of believe in conspiracies surrounding these events, that they were sort of authorized by government, and the media controlled the situation and things like that. And whilst that employee did honestly hold that belief, it was a belief, from a general sort of term of belief that was held, and it did, relate to weighty and substantial aspects of human life. It ultimately didn't meet the bare minimum standard of coherence or cohesion. The tribunal went as far as describing the belief as being absurd. So it simply was one which is not going to satisfy that test. Vegetarianism, I think, is always quite an interesting one to include in here when you're conflicting with against that previous slide we had of veganism. Okay, you'd think, well, with veganism, why isn't vegetarianism? But the difference here is it doesn't necessarily satisfy all the hurdles. In this instance, the belief did not concern a weighty and substantial aspect of human life and behaviour, and didn't have a certain level of cogency, seriousness, and cohesion. I think really, the prior case, which I spoke about in a bit more detail, we weren't just looking at vegetarianism in general. This was someone that had ethical veganism. It went across his entire life. There was and dealt with all aspects of his life, and the way he operated at work and things like that. So that's sort of the key difference. And interestingly, in the two cases that dealt with the veganism and the vegetarianism, it's the same employment judge that heard each of those, and I think that's really useful sometimes to know, because it's not just a question of, oh, did someone just apply the test slightly differently? It's the same judge that's addressed both of those issues and come to those outcomes. So there's some examples. I mean that, and just in interest of time, as I say, I won't go through all of these, but the English nationalism one at the bottom. I mean, we're talking not just a sort of political view, but an extreme, form of it, akin to Nazism. Simply was obviously, not found to be worthy of that sort of respect, and was incompatible with human dignity, and as such wasn't held to be protected. One other one, just because I think it is something that in some ways may be more likely to come up in a workplace, that we don't have on the slide here, but I thought might be of interest to people, and particularly in light of, and I don't by any means follow football myself actually, but if Arsenal's success this week, it relates to football fans, and it's a case by the name of McClung. And in this case, the claimant, Mr. McClung, was a avid fan, to say the least, of Glasgow Rangers. He had been for 42 years, never missed a match. And when questioned about this, he described it as a way of life akin to a Christian attending church. So that's, he clearly, he felt very strongly about it, but ultimately his belief in his club absolutely didn't reach that threshold for being a protected belief. The tribunal found it was more of a lifestyle choice, effectively. There's no cohesion in the ways the fans act, i.e., not all fans were to that extent. They don't share the exact same beliefs, and so on. And it wasn't worthy of the same level of respect as something such as the ethical veganism and things like that. So it doesn't meet that threshold. But as we touched, the case law is ever evolving on this, and the reason be it, as you can see, it is each belief almost needs that separate test being applied to it in consideration on a case-by-case basis. So it is something that is frequently, I think, litigated. So that's a bit on, what may or may not. We then look at what is to be protected. Okay. And when we're looking at that, it's effectively, if someone holds that belief, we've got a the belief for holding on the belief itself is always going to be protected if it is a protected belief. Okay, so someone cannot be discriminated against or harassed because of their belief. However, when it comes to expressing and how they express that belief, that's when the protections may not go as far, simply because they hold a belief and that belief is protected doesn't give them open rein to do as they please about that, and that's about how it's expressed and how it's manifested, and that's where a lot comes into this. I'm just going to talk quickly and just address a question that's popped up, because I think it sort of starts to come into this, and hopefully then in our next section it will almost naturally address it. But there's one of the questions been asked about the gender critical beliefs issue and Higgs, and as I say, this is one of the more relevant and more recent cases, and it was the question is effectively, why are they protected when arguably it infringes human dignity of certain individuals? And ultimately, I think the issue here comes into, and where the courts and tribunals are perhaps a bit hotter on things at the moment, it's not the holding of that belief itself, but actually how an employee manifests that belief, what they do with that belief. And as I say, they don't therefore have sort of open rein to do anything with it. If we look at the next slide, we talk about manifestation and how the belief is expressed. And what we're talking about here is an employee's speech, their conduct, appearance, for example, i.e. they dress in a certain way, perhaps they might the easy example is obviously things like religious symbols, but obviously this, we're not necessarily talking about strict religion and things like that. It might be something else. How they behave towards other colleagues, what they might do on social media, and as I say, there are protections when it comes to manifesting beliefs, but it's not they don't have, as I say, sort of carte blanche to do as they like, and an employer can take action in as a result of the way something has been manifested. However, any response needs to be reasonable, justified, and proportionate. And this is where the Higgs case really went into some detail. So I've already spoken about Higgs in the fact that her belief was found to be a protected belief, this gender critical sort of belief. However, she was ultimately then dismissed in this case. However, that dismissal was found to have been disproportionate response. And let me explain, obviously give you a bit more for context of the case, which will help provide a bit more sort of explanation behind all of this and the factors that someone looks at when you're dealing with a manifestation of how that is expressed. So Higgs had been a teacher at this school, at Farmer School, for 6 years, okay, in total. And it was roughly in 2018, so a little bit earlier than a few years prior to the case, she had posted on Facebook, and I say posted, she'd reposted, shared on Facebook various posts which were gender critical, okay, and spoke about gender critical beliefs, and particularly when it came to sort of schooling education, and was referring to a lot of things as being brainwashing and things like that. Now, ultimately, a complaint was raised by a parent who basically said, well, they're her views. What on earth, is she teaching to the children? And is she not going to be, isn't there a risk that she'll discriminate against, a child that's perhaps, it might be, trans himself or something like that. So that triggered ultimately an investigation, disciplinary processes and so on, and led to her ultimate dismissal. but a tribunal found, that was not, as I've already said, that was the disproportionate response to it. An employer still has this requirement to show their response was reasonable, justified, and proportionate. Going behind this a bit more, though, the reason they found it was sort of disproportionate was there hadn't actually been any reputational damage. Yes, this parent had discovered it, but it wasn't publicly open and available. Her Facebook was closed to a network of roughly 100 people. She used her maiden name on it, so it wasn't, it was difficult to link, and indeed there was no reference to her job role linking her to a school available on it. So it was very much isolated in that sense. The posts were her own words, and indeed she actually, during the course of the investigations and stuff, stated she didn't agree with some of the language that they used, albeit she did share them. And there was no impact on her teaching. It's something she said, look, it's 3 years old. It's never been any issues. I won't let there be any issues. It's not going to happen. And we can, she can show it's not impacted that, and was very clear in that. And assessing all of these factors, including the likes, as I say, the fact there was no real link to, the school or any damage or anything like that. It was almost viewed as more that I appreciate they went for a process, but a knee-jerk reaction effectively, and it was found to just be completely disproportionate. So really, there needs to be a bit of as I say, it underlines the importance, and it is better if we can go on to the next slide, sorry, of when assessing the expression, of being sort of taking a careful context-specific assessments in cases, because something actually might be unproblematic on a private closed forum, but actually, if those views were perhaps expressed in her workplace, absolutely could have had a different result here. If she was saying those things in work, posting that on an intranet site, or emailing, talking about that with colleagues at work in that way, I don't think anyone denies that could have had a different outcome. So it's looking to assess those on a case-by-case basis. And when we're looking at what to assess, it's indeed only see some key obvious examples here is what's been said, how it was said. So what was the tone and the language and the context behind that, and again, the where and when. Who was affected, who was the audience to that, what's the impact that's had, and then what's the business impact, i.e., for example, if it was more on an open public forum, is that going to have a reputational issue, or anything like that? Okay. They also, and following sort of the Higgs case, there were some various sort of other things to be looking at, and it's looking at, again, when dealing with that, any interference with someone's expression of their belief should always be done in the least intrusive way to reach that objective, i.e., so in the Higgs case, the dismissal was just found to be too much, that's going too far. The content, tone, and extent of the statement, as we've already said, need to be looked at. An employee also needs to consider, whether they've stated the views are, whether they are personal views held. So sometimes, like you often might see someone sharing something. Indeed, for example, saying, someone like myself, as a professional might share a legal update or something like that on LinkedIn, or a commentary on a legal case or something like that, and that's not to say it's my views, and if I disagree with something, that I'm likely to give some form of caveat to say, this is really interesting. However, to be clear, the views held in this aren't necessarily my own. So it's how it's sort of presented. So there's all sort, all those factors need assessing, and it's really a lot of cases more recently aren't looking at, is it a protected belief or not? It's about the manifestation. How's an employee presented that? And is the action that's subsequently been taken proportionate and sort of justifiable? And it's at that junction I'm going to hand over to Isabella, who's going to look at some of the more practical applications of all of that.
So as Sam's been taking you through, we've been looking at what is a belief, what may not be a belief, the difference between a belief and the manifestation. But now we're going to look at how to avoid discrimination risks with the protected beliefs when issues arrive in the workplace. So A key starting point for this will be that your actions should be based on the conduct and not the belief itself. So that's the distinction that Sam was just talking about with the belief versus the manifestation. So when an issue arises, first you should pause and consider, what are we actually responding to here? Are we responding to the belief? Does it conflict with something we believe and we find it a bit grating? Is it a bit controversial? So consider what you're actually responding to first, or is it how that belief has been expressed? Because the distinction between the two is critical. Two employees may hold the exact same belief, but the way that they express that belief can be different. One might do so in a respectful and appropriate way. The other might do so in a way that's offensive, disruptive, or damaging. And then in that scenario, we would take different approaches with the two employees because of the way they've manifested that belief. So we also have to consider whether the restriction on the right to manifest that belief is a proportionate means of achieving a legitimate aim. And that legitimate aim might be protecting colleagues or maintaining a respectful workplace. So even where there is an issue with the conduct, the response needs to be proportionate to that conduct. So again, you pause, you ask yourself, is formal action necessary? Could this be dealt with informally, perhaps through guidance, one-to-one conversation, explaining why that expression isn't appropriate, or maybe some training instead? And finally, the approach you take has to be consistent. If you treat similar conduct differently, depending on the belief behind that conduct, then there's an increased risk to you. So the key question should always be, would we take the same action if the behavior were the same, but the belief behind that behavior was different? So this is where things can become a bit more complex, and I'm sure many of the incidents you come across might be between competing rights of different employees. So you may have one employee saying that they have the right to express their belief, and then you may have another employee saying that belief negatively impacts them. And both individuals may be protected under the Equality Act because they have particular protected characteristics, and then the other has protected belief. So common examples, which I'm sure you'd also think of, are when religion or belief conflict with sexual orientation, or when gender critical beliefs conflict with gender identity. So again, regardless of personal beliefs, we have to take a step back and realize that one of the most important points here is that there's no hierarchy of rights. So no protected belief will automatically take priority over the other. And likewise with the protected characteristic, it's not your role or our role to decide who is right or wrong in a moral sense, but to determine what behavior is appropriate in the workplace. So what we're doing here really is balancing competing rights. It's the rights to express a belief against the rights of others and the needs of the organization. So I think a helpful way to think about this approach is to take it as you're not there to resolve the debate, you're managing and addressing the workplace behavior to make sure that that is appropriate. So how do we approach that balancing exercise? First, as I keep saying, we have to put our personal views to the side and we have to remain neutral. We don't want our personal views influencing your or our decision making. The second thing is to be evidence-based. Focus on what actually happened. As Sam said, what was said or done, how was it said or done, and what was the impact of the expression of that belief. It's important to avoid assumptions as well in that sense about the intent or belief behind the words or the actions done. Thirdly, the principles must be applied consistently. So using the same framework ensures that your decisions are consistent. That's why it's important to have your policies and make sure you're referring to those when you're going through them and making sure you're sticking to the same process that they set out for you. And finally, again, as we'll keep saying many times throughout this, you have to focus on the impact rather than the ideology. Don't get distracted about whether the belief is controversial. It's about the effect on the colleagues, the team, and the workplace, because the same words can have very different implications and consequences depending on the context. So it's always important to consider it within the context of how it was said, who it was said to, and what was said specifically. So ideally, of course, we want to avoid these conflicts escalating in the first place. Conflicts are inevitable in a diverse workplace. We should expect them. Debate is healthy in many ways, obviously, but it's about managing it effectively. So the first and the sort of basis to all of this would be to focus on the culture. So creating a workplace where dignity and respect are embedded within the business will help prevent issues from escalating. So that healthy debate potentially there as well. This has to go throughout the whole business. It has to be throughout the whole company that it's demonstrated that you're an inclusive culture, and that's important to the business and senior leadership, etc. It also helps as well, we've just spoken about policies, so having clear policies in place and making sure they're applied consistently across the company. It helps to set out an expectation of the expected behaviour, but importantly, the policies must focus on regulating behaviour rather than suppressing the beliefs. So, for example, rather than trying to prevent an employee from holding or expressing a view, it's ensuring that they are done so in a respectful way. And finally, training people is critical, as in many things. Managers rather, will be the first to deal with these issues, and their responses can help resolve or escalate the situation and leave something for us to sort out. So complaints and grievances, when these issues do arise, it's the way that we handle them that's even more crucial. So as always, we want to act quickly, remain neutral, and carry out fair and thorough investigations. Again, a common mistake would be to treat the belief as the issue rather than the expression. We have to focus on the on what was said and done, the context and the impact, not the belief itself. So we need to distinguish between the two. So as part of the investigation, we need to ask what was said, how was it done, who was affected, and what was the impact. And at the outcome stage, we would want to make sure our reasoning is clear and demonstrates that our response was proportionate to the behaviour that we were investigating. And as always, it's important that our reasoning is clearly documented, because if it escalates to tribunal or anything, then we want to have that documented so that we can set out why that behaviour was proportionate in that scenario to that action or whatever had happened. So far, when I've been speaking, I've been assuming that the beliefs are protected and qualify for protection under the Equality Act, but it may be that you assess the belief using the criteria that Sam spoke you through at the beginning of the webinar, and perhaps you've taken advice, discussed it with colleagues, or taken advice from us or another solicitor, and you've determined that actually that belief probably won't qualify for protection. It may be then in that scenario that we're not following the processes that we're talking about now, and it's just your standard disciplinary process that you're following, dependent on the behaviour in question. However, if we do consider that the belief does qualify for protection, then again, that key principle that I keep harping on about remains, that we are taking action because of the conduct, what the employee had done or said, rather than the belief that they are holding. So if we think it is a protected belief, then we have to be really careful that we are responding to how they have presented that belief, not the belief. So again, we want to ask ourselves, would we take the same action if the behaviour occurred for a different reason? So again, context, intent, and level of harm caused must be assessed in order to ensure that our response to that behaviour is proportionate. So we want to be cautious as well about applying rigid zero tolerance policies and ensure that the policies we do have are applied consistently across employees to ensure fairness and consistency and response from us. And finally, as always, again, we want to make sure the decision making and the reasonings behind that are clearly documented. So not every issue, as I've said, may escalate into a formal grievance or a disciplinary process. In many cases, early intervention can resolve the issue more effectively, as with many other scenarios. So again, this probably links back to the culture point. If you've got a culture which encourages an open discussion, we can then focus on the impact of the behaviour as well, rather than the intention. It may be that the employee doesn't intend to cause harm, doesn't appreciate the impact of their words, and a simple sit down with the manager, with HR, with whoever, and just a sort of explanation to say, this is why that didn't land the way you think it did, might be able to prevent it escalating into a formal grievance or a disciplinary process should the behaviour worsen. Again, it's important that the managers remain impartial, and we're not challenging the validity of the beliefs in those sorts of conversations. We are focusing on how that person has expressed that belief. Moving on to policies now. Again, it can be one of your strongest lines of defence. They will set out the expectations you have of your employees and emphasise the importance of respect, whilst recognising that employees can hold differing and conflicting beliefs. Again, the policies must regulate the behaviour, not the belief itself. And if it does happen that unfortunately this does escalate to a tribunal, it can also form part of your legal defence if they bring a claim, because you can help demonstrate that you took reasonable steps to prevent the discriminating behaviour, amongst other things, as well. So again, as I said at the bottom there, policy should regulate behaviour and not restrict the beliefs. I've mentioned it before, but just to sort of hammer the point home that training is critical. Managers are often the first to respond to issues, and this is obviously quite a contentious area. So their handling of the situation can make a really big impact to the outcome. The training would focus on on equipping managers on how to handle the sensitive situations, how to balance those competing rights, and how to de-escalate conflict. Without training managers and others within the business, there's a high risk of inconsistency in approach, and then more likely going to be some escalation then. Social media, so as with the Higgs case that related to social media, it's a growing source of workplace disputes. What employees say in a personal capacity can become a workplace issue if it sufficiently impacts their colleagues or the reputation of the business. But as Sam said, the reputational risk to the business point has to be carefully considered, because with the Higgs case, it was about the school was concerned about the potential of future reputational damage rather than having suffered actual damage because of the post. And as Sam said, there was no risk that a reader of the post was going to think that it was the school's opinion rather than the claimant's. So just be careful of the reputational damage point there with social media. And the social media policies and other policies that relate to social media should always encourage respectful communication and make it clear when personal views might give rise to workplace concerns and subsequent action that may be taken because of that. So to sort of summarize what I've said here, there's no hierarchy of rights for the protected characteristics or protected beliefs. We have to focus on behaviour and impact. The beliefs are protected if they satisfy the criteria, but we can manage the behaviour if it, goes to a certain point, and we're obviously focusing on the impact of that behaviour. Any response that we take to the behaviour has to be proportionate. So always consider, is this a proportionate response to what's happened? Early intervention can prevent escalation, and strong policies supported by well-trained managers will also afford you some good protection here. Ultimately, as HR and as lawyers as well, it's not our role to resolve the debate here. We are trying to manage the workplace so that it's fair, consistent and lawful. What we can do for you, if you want some help with this, we could review your existing policies that you have or draft new ones for you. We can help deliver training to different parts of your business, whether that's managers or the senior leadership team, for example. We could give you ad hoc advice if a situation arises where you're not quite sure if that does qualify as a protected belief. We can help you figure out what approach we want to take with that. And then also, if you do decide that it is a protected belief, how do we ensure that our response is justified and proportionate going forward to limit the likelihood of a successful tribunal claim? Because obviously you might not be able to limit someone bringing one, and making sure that a disciplinary process or a grievance process is handled appropriately, considering this sort of higher risk area. And then finally, if fortunately it does escalate to a tribunal claim, we can help advise on strategy and draft any of the necessary documentation for the tribunal. And if anything we've discussed relates to something that you're going through at the moment, obviously we're happy to talk to you separately to the session afterwards as well.
Yeah, brilliant. Thank you for all of that, Isabella. I just wanted to come back before I mean, you'll see on the screen there's the sign up to our mailer that while I'm talking, if anyone isn't signed up and wanted to, they are welcome to do so. But I just thought I'd come back to the question that popped up and I sort of addressed earlier. I think I can expand. I sort of did try to do so within the flow of the webinar, but I just thought I'd come back to it to give just a bit more of a answer, really, and perhaps a bit more of a direct answer. So by way of reminder, the question that was asked was about gender critical beliefs, and why effectively that is protected if it arguably were to infringe the human dignity of certain individuals, i.e. trans people. And the difficulty that question highlights, and for the right reasons, is how easy it is to hit the conflict in the workplace. There's people that will hold such beliefs, and naturally those that do not. But just, I think in every instance, if there was a conflict, it doesn't, you can't just be not protected because everyone doesn't necessarily share that belief. And the answer, though, to the question about human dignity point is on that last, that human dignity falls into the very last criteria in that test. And the threshold is a high one. And a case that was going on just prior to the Higgs one, it was called Forestarter, and they actually had overlaps through the appeal processes and things. That it is a case that originally found about gender critical beliefs being protected, and that case held basically the threshold there for the human dignity. To fail that threshold has to be high, and I mean considerably high. And the references they refer to is the likes of totalitarianism or Nazism level of beliefs and things. So it simply just isn't at that threshold. And the issue really again comes back to, it's not someone holding their belief. They're entitled to, and that can be a protected belief. But as we've sort of discussed, it's when that enters the workplace and as that's manifested is where those issues arise. So whilst the belief might be protected, as we've said, it doesn't give that carte blanche to go and say and do what you want with that belief, offending people with it, harass them with it, and so on. And that's where that conflict then needs that active management. Obviously, well, I've just actually seen, I was about to say if there's any other questions, I have just seen it's expanded under the comments on that one, which I didn't realise was there. There is another one. And I'm going to politely say to the person that asked it, I will come back to you with this because it's sort of, whilst it is very relevant to what we're discussing, it falls into a bit of a wider sphere about freedom to speech and sort of freedom of speech within sort of the educational sphere and environment, and that does overlap with what we're discussing. But it goes a lot further beyond that. In fact, there's a case which is getting in, I'm going to say the Supreme Court today, dealing with this issue. So I'll come back on it and follow up directly on that. I mean, the answer, but one answer to that. So the question, for those that might not have seen it, was effectively in a university setting, how far can an individual from one faculty assert gender critical or theologically barren commentary when it does not immediately fall within their sphere of expertise? It's going to, I mean, that's going to end up being very fact specific anyway. What is it they are asserting? Are they asserting it as their view? How are they expressing it? Or are we talking from an educational, perspective? As opposed to, because if it's not a belief, they hold, and it's not their belief in it, and it's not one that satisfy it, then the normal, as Isabella was saying, rules are going to apply. But equally, they're doing it from an educational perspective. Well, again, if it's falls outside of their expertise, something they're not teaching, again, normal sort of disciplinary rules may apply. But as I say, I will follow up in a bit more detail directly on that one. So thank you everyone for joining us. As for those that have attended our webinars before, always Isabella and or myself will look to follow up with everyone with a copy of the slides, a link to the recording of this webinar. So if you want to revisit anything we've discussed or share it with any team members and so on, you are you're welcome to do so. In terms of our next webinar, you would have seen it's been on the screen for a little bit there. There's a sort of QR code that you can scan to be able to sign up to it. It's going to be on the 18th of June with the lovely topic of secret recording and deep fakes, which is partly looking at the likes of AI content and such like, and the rise of that, as well as how, with AI software, there's the rise of covert recordings and how that's used, what position that sits in the tribunal, and so on. So it's set to be interesting. That's with my colleagues, Hannah and Alice. So yeah, feel free to sign up and join us. But unless there's any other questions or anything like that, then again, all that's left is to say thank you for joining us. And hopefully, well, I won't see you all, but we will see you all next time.